Good morning. This is Kathy Walsh. Thank you for joining us for the Legislative Update webinar. We are going to wait just a couple of more minutes till exactly at 10, and then the webinar will begin. All right, good morning, everyone. This is Kathy Walsh, Director of the Tennessee Coalition to End Domestic and Sexual Violence. I'm so glad that you could join us today for the legislative update. We tried to host this a few weeks ago and had some technical difficulties, but hopefully we've worked that out today. So before we begin, I wanted to check in and make sure that everyone can hear me and see the PowerPoint. If everything looks and sounds good, please let me know in your chat box. All right. So we will go ahead and get started. You can type in some questions, and we will make a note of those and try to answer those questions at the end of the webinar. You should also have a copy of the PowerPoint on your screen so that you can see that during the presentation. All right. So I always like to start out and talk about the number of bills that have been filed. And you'll see that last year there were 2,686 bills filed. And what we do with the coalition for our members is we look through all of these bills and we pull out bills that we want to track that we think will be something that our members are interested in. So you'll see that we tracked 210 bills last year. And of those bills, 104 of those track bills did pass. And that's in addition to the rest of the bills. The total number was 767 bills that passed. So the General Assembly typically meets from about second week in January to mid or late April. And so it's very quick sessions these days. And also we send out legislative alerts weekly to our members throughout the session. So if you're not currently signed up to get those legislative alerts, please let us know and we will add you to that list And so, I always tell folks that when session's going on, we'll write summaries of bills that we have taken positions on, whether we're supporting those bills or opposing those bills. At times, you will also get alerts that will let you know that it is time for you to call your legislator about that particular bill. So weekly, we'll let you know what bills are coming up and are going to be in committee, and if there are any actions that you need to take. So the General Assembly is in hiatus and will return on the 8th of January in 2019. So we have a little time in between sessions. Also, we will be surveying our members and working between now and when session starts to know if there are things that we need to go ahead and get on our legislative agenda to bring forward to members to sponsor bills next year. So we certainly want to hear from you if you're seeing any issues that may be legislative issues that we need to address next year. All right, so the first bill I want to talk about is Public Chapter 507, and let me just mention public chapter versions of the bill. The PC stands for public chapter. So during the session, bills will get filed in their original format, and then most bills will get amended somewhere along the way. So if you're checking the legislative service and you're reading the original bill summary, you also have to pull any amendments because the amendments may change that bill totally or amend that bill in some way. And so it isn't until after session is over and these bills have passed that they release a public chapter version of the bill. And in the public chapter version of the bill, the entire bill is there. So they've taken the original bill, they've added all the amendments to it. So it's an easier way of viewing the bill. So as we go through these bills, I will note the public chapter numbers of the bill, and you can use those to find those at the legislative website and just give you a brief summary of them. So one of the bills on our agenda last year was the sunset bill for the Domestic Violence State Coordinating Council. This is a council that has been in existence since 1994. It is comprised of representatives from the courts, law enforcement, social service agencies, and the purpose of this council is to develop model policies and training curriculums for law enforcement in the courts. And also, this is the council that developed the rules and certification process for batters intervention programs. And the council now does the certification and monitoring of the programs, as well as the council is great on working on emerging issues and also works with the Administrative Office of the Courts to update the order of protection forms every year based on policies that may have or bills that may have passed in that year. So we're very happy that that the council was extended for another 4 years. The next bill that I want to talk about is PC 578. And this bill is really, I'm going to call it a cleanup bill in a sense. A couple of years ago, there was a bill that was part of the governor's safety plan. And one of the provisions of that bill was that at a defendant's initial hearing after being arrested for a crime involving domestic abuse, that the magistrate or judge would issue a mandatory temporary order of protection. Well, there were some problems with that practice because there was no discretion for courts if there was already an order of protection in place. So now suddenly you ended up with 2 orders of protection. It was something that the victim had not requested. So often victims didn't even know that an order of protection had been filed and therefore didn't show up for court hearings to possibly testify in that case. We also know that some victims feel like an order of protection might place them in greater danger. So this is a practice that was really not victim-centered. I think it was well-meaning of trying to deal with some of the more severe cases when there was serious bodily injury or a deadly weapon was used, but it just didn't work very well. And so courts were very frustrated about this practice because they would issue these temporary orders, victims wouldn't show up for court, and judges would end up dismissing the orders. So what the legislature did last year was to take this out of the Order Protection Code and instead amend the bond condition statute to require in those cases where serious bodily injury had occurred or a deadly weapon was used, that there would be a mandatory no contact order issued as part of bond conditions. And many of you already know that there are mandatory bond conditions in every case that where domestic abuse is part of that case. So judges or magistrates should be already imposing different sanctions or bond conditions when domestic abuse offenders are bonding out of jail. This just adds an additional bond condition that's mandatory, again, when there's been serious bodily injury or a deadly weapon has been displayed. It also requires in those cases that the judge, again, impose a 12-hour hold, provide victim notification. So in cases, just to refresh your memory, in domestic abuse cases, judges currently are required to impose a 12-hour hold before releasing the defendant if they feel that that offender is a danger to the victim. And if they feel they're not a danger, then they have to actually write that in the order. So most, our experience is that most offenders of domestic abuse are held for 12 hours around the state. I want to clarify, because you may get some questions about this, that this bill doesn't prohibit the court from also issuing an ex parte order or order protection at the request of the petitioner, just like it always has. It didn't change that statute at all. Some folks were concerned when we went in and took this mandatory provision out of the order protection statute requiring issuing a temporary order, that somehow that meant that judges or magistrates couldn't issue an ex parte or full order protection. They can, just as they always have. It just moves this provision in these cases where there has been serious bodily injury or the deadly weapon displayed, making it a mandatory bond condition that a no contact order be issued. It really is the best practice to have both an order of protection and bond conditions. Because and sometimes we get these questions when they say, well, the judge has already issued these bond conditions that say there's no contact. Do we really need an order of protection in addition to that? And we say yes. We say yes because the bond conditions are only good until that case goes to court. The order of protection generally is good for up to a year, and it has relief that victims can get. So, for example, in addition to requiring the defendant to stay away from the victim, it can also do things like award temporary custody through the order of protection, set up safe visitation, order support for the victim or the children, give the victim possession of the household. Require the perpetrator to go to a batterers intervention program or a drug and alcohol program. So there are lots and lots of things that can happen with an order of protection that certainly does not happen with bond conditions. So again, this will allow or require in these most serious cases that there's a no contact order in addition to any other bond conditions, but there should also be an order of protection issued if the victim wants the order of protection. The next bill, PC 597, is really a cleanup bill. We call call it a cleanup bill to clean something up that was passed last year. So last session, a bill was passed to clarify the notification and firearms dispossession procedures for offenders convicted of a misdemeanor domestic assault. And so in the statute, it lays out that if you are found guilty of a misdemeanor domestic assault, or if you're under an order of protection, that you must dispossess your weapons and file an affidavit with the court within 48 hours. Last year, a bill was passed to clarify that procedure for the misdemeanor dispossession. But unfortunately, the bill did not reference the firearm prohibition in state law. It only referenced the firearm prohibition in federal law. So this cleanup bill went back in and put that language in that was accidentally left out last year when this bill was passed. And the reason why that's important is because the gun prohibition laws throughout the statute need to reference both state and federal law, so that we have the so that TBI has the widest discretion, or not discretion, but rather ability to prohibit abusers from being able to purchase weapons. All right, PC 609. This bill requires that the family life curriculum include instruction on the detection, intervention, prevention, and treatment of child sex abuse, and it extends the immunity from a cause of action to instructors or organizations providing such instruction in accordance with state law. And some of you may remember that a number of years ago a bill passed, and they called it the Gateway to Sex Bill. And what that bill did is it set up a cause of action so that if a parent didn't like what an educator was teaching around sexual assault, that they would be able to sue the teacher. And so that had quite a chilling effect upon advocates who go into the school to do this training and so on. So with this bill, it is going to require that a curriculum be produced, and that if the teachers or the advocates are using that curriculum, that it will set up or it will extend an immunity from cause of action. So we think this is a very important bill because we all know that prevention needs to start earlier and earlier with children and be able to get into the school system and do the prevention work and not be concerned about a lawsuit. Is going to be very important moving forward. PC 729, this is a very exciting bill. This bill allows a victim of domestic abuse to petition the court to have the billing responsibility and rights to the wireless telephone transferred to the petitioner if the petitioner and children are the primary users. So we often see this where we have victims where their phone is part of the perpetrator's plan. And so the perpetrator can cut off access to using that phone. And victims sometimes have trouble going, they don't have the money to go and get a new service and get a new phone in their name. So this law will allow, through the order of protection, again, another form of relief, that the victim can ask the judge to order the telephone provider to basically bifurcate that plan if the plan's in the perpetrator's name. So it means that the victim and children who may have phones, that the court can order the telephone provider to move those numbers into the victim's name and let the perpetrator keep his number. But the victim in that case, or the petitioner, will assume all the responsibility for paying the bill. But again, I think this is very helpful because we know that wireless phones are really a lifeline for victims if they need to call the police. So we think this will really add to victim safety. PC 1004 is a safe at home confidentiality program. And what this bill does is it requires the Secretary of State to create a crime victim address confidentiality program for victims of domestic abuse, stalking, human trafficking, and sexual offenses. So along with this bill, the Secretary of State's office will be promulgating rules related to this program, and victims will be able to apply to the Secretary of State's office to get a confidential address, a P.O. box, which again adds to the victim's safety, and that P.O. box will be able to be used on bills and so on to protect the actual address of the victim. Now, this bill doesn't go into effect until March 1st to give the Secretary of State some time to get the program together. And recently, when I was talking to the Secretary of State's office, we were talking about the documentation or evidence that would be needed for a victim to be able to qualify for the program. And what's in the statute now is that the evidence would have to be either an ongoing criminal case that may result, or a criminal case that has resulted in a conviction by a judge or jury, or by a defendant's guilty plea, in which the applicant or the minor or person with a disability whose behalf the application was filed was a victim of domestic abuse, human trafficking, rape, sexual battery, or other sexual offenses. A court of competent jurisdiction has granted an order of protection. In the absence of an ongoing criminal case or conviction or an order of protection, a notarized statement by a licensed professional of the circumstances, such as an attorney, social worker, therapist, confirming that such individual believes the applicant or the minor or person with a disability on whose behalf the application is made is in danger of further harm. So the part that we have some concern about is that we feel that there should be an additional avenue. So, for example, when we currently have a confidentiality address program where a victim of domestic violence can ask that their utility records, for example, not be public. And already in the statute, it allows someone to take an order of protection or some other order from the court, but it also allows a letter from a domestic violence shelter or sexual assault program saying that they're working with the victim. And that's the part that is actually missing from this particular statute. And so that is something we want to work on early in session next year to try and get that added to this statute, hopefully before it goes into effect, or at least by July 1, because we all know that we're going to have cases where you may have a shelter that's working with somebody and they don't have a social worker or licensed therapist that's working with them. And so we feel like we need another avenue for some of those cases. But again, this is a program that they already have in many states. It works very well. We know currently that there are domestic violence programs that allow victims to use their P.O. box to get their mail for a certain period of time. This will enable that to happen through the Secretary of State's office. And it's my understanding that they will collect all that mail themselves and that they will forward it to victims. So it could be a pretty large program, but we will be working closely with the Secretary of State's office to get this program going and to make sure that all of our programs know how to access that. PC 975 relates to aggravated stalking offense for a victim under 12 years old. So it broadens the statute on the offense of aggravated stalking to include a victim who's less than 12 years of age if the offender is 18 years of age or older at any time during the person's course of conduct. So it makes that an aggravated stalking offense. PC 951 prohibits a person charged with incest from participating in judicial diversion. Again, we think this is important. Currently, judicial diversion is something that the court can do, and many of you are familiar with judicial diversion, so that if a defendant pleads guilty to a particular crime that's eligible for diversion, the court will set up certain things that that person must do to complete. So, for example, you might have a batterer who has to go to a certified batterers intervention program or a drug and alcohol program. And if they complete that program and there are no other offenses for a set period of time, then their record can be expunged. So what this does is it says that judicial diversion will not be an option for any person charged with incest. So again, I think it's a very good bill designed to protect children. PC 801 deals with law enforcement and child welfare. This bill requires law enforcement to ensure that whenever a person is arrested and taken into custody, the person is asked whether they're the parent or legal custodian of any child that will be left unattended by the person's arrest. The officer must determine whether the child or children will be endangered by the parent or legal custodian's absence following an arrest. It also requires law enforcement agency to develop policies and procedures for conducting welfare checks on any child identified as endangered. The welfare check must be performed by the arresting agency or another agency responsible for ensuring the safety and welfare of children. The bill specifies that the arresting law enforcement agency and its personnel will not be held liable if the arrested person fails to inform the arresting law enforcement agency of any children left unattended as a result of the arrest. So again, I think this is a good bill. We want to make sure that there aren't any children in the home who, if left unattended, would be in harm's way. PC 719, it extends the Tennessee Sexual Offender and Violent Sexual Offender Registry Verification and Trafficking Act of 2004 to include the act of continuous sexual abuse of a child as a violent sexual offense. And so those of you who are familiar with the sex offender registry, if you're in the classification of a violent sexual offense, you have to stay on the sex offender registry for life. PC 898 prohibits a convicted sexual offender from living or working within 1,000 feet of a school, daycare, or public park. PC 1050 revises existing provisions and creates new offenses regarding the abuse of the elderly and vulnerable adults. This is a pretty comprehensive act, and I encourage you guys to go on and get a copy of that and review the provisions of the act. I think this is a first step in trying to enhance adult protection laws. Again, a very important bill. PC 560 authorizes a parent to relocate with a child if no objections have been made by the other parent. Within 30 days of the date, the notice is sent by registered certified mail. So if you're working with a parent who is relocating for a new job, for example, or other reasons, current law requires that parent to notify the other parent that they're going to be moving. And they must do that by registered mail. It requires the court to determine whether the relocation is in the best interest of the child. So courts are looking at that, and I think this is an issue for advocates in terms of helping victims who want to relocate prepare to present their case about why relocation is in the best interest of the child. So I'm anxious to see how this is going to play out. PC 905 authorizes the winning party to collect attorney fees if they alter, change, or modify any decree of alimony, child support, or provision of a permanent parenting plan. Um, Previously, the statute, um, was not clear about one party collecting the attorney's fees. Again, I'm anxious to see if this will have a negative impact on a victim of domestic abuse who wants to modify, say, a parenting plan, and they file to modify that parenting plan, and the court doesn't do that, then the victim could be charged with the attorney's fees. So I'm kind of anxious to see how this is going to play out, because we don't want to discourage a victim of domestic abuse from wanting to alter that parenting plan if they think it's in the best interest of the child. PC 873 prohibits local government activity that interferes with the enforcement of federal immigration laws, with a prohibition against any state or local government entity or official enacting a sanctuary policy. This was kind of a hot topic during the last legislative session. It's my understanding that we didn't have any sanctuary cities in Tennessee, but there was a concern about that. As you know, the coalition does provides direct legal representation for immigrant victims of domestic violence, sexual assault, and stalking. And, I think that this bill, along with other actions like raiding plants and so on to look for undocumented workers, has really had a chilling effect on immigrant victims of domestic violence, sexual assault, and stalking, calling the police or coming forward out of fear of being deported. And so I think what's going on with policies at the national level, the state level, are just increasing those fears. And it makes documented immigrants, I think, at greater risk of being victims of crime because they're afraid to come forward. So we're certainly working with our clients. We are trying to reach out to communities to provide assistance to immigrant victims in those situations. PC 764 imposes a $2 privilege tax for each customer entry to an adult performance business. Revenue collected through this tax will be allocated to programs for victims of sex trafficking. Some of you may remember a number of years ago, the coalition worked on a bill, a similar bill to this, that would have had those funds go to sexual assault programs in the state. We were not successful in that effort. This year, this bill passed, and as you'll notice, the funds will be dedicated for victims of sex trafficking. So if you're working with victims of that particular population, you may want to look a little closer into how that money is going to be distributed. Senate Bill 1574, House Bill 1940. This is a bill that did not pass, but I wanted to mention it because it was on the coalition's agenda. We took a position against the bill. This is a bill that tends to come back every single year, so it may come back next year. So I want to mention it now that we have a position against this bill. It would have required persons committing a misdemeanor domestic assault or violating an order of protection to be placed on a domestic abuse registry maintained by TBI for a period of 10 years from the date of conviction. We oppose this bill because we believe it would have discouraged victims from calling the police for help. Again, in those situations, an offender going on the registry might increase the fear of retaliation against the victim. Also, we know in many cases, a victim may want to try to reconnect with the perpetrator, and then you're going to have a situation where that could also out the victim, if you will. If the perpetrator is on that registry, then people are going to know that that person or those children, that the spouse or husband is on the offender registry. I think that could create a problem for some victims that they would not want to call police for fear that they may end up, the perpetrator may end up on the registry, and it would be a negative consequence for the victim. So again, I anticipate to come back next year. You'll see more stuff about this if it does. So I've mentioned again the public chapter versions of the bill. If you're not already familiar with the Tennessee General Assembly website, here is a link to the website, and you can go under the tab of legislation, and from there you can either search these bills by bill number or by public chapter number. And if you have difficulty doing that, please let us know, and we'll make sure to send you a copy of the bill. For more information and resources about the coalition, I hope that you will check out our website. We do offer trainings throughout the year, and so there's a training calendar on that website. We have lots of different resources like bench cards for judges and selected law book, and various policies and best practices that are on there, and so we hope that you will utilize that. Remember that the coalition's trainings that we do are free, so if you're interested in having the coalition do some training for you in your local community, we're happy to talk with you about that. We have an annual conference every year that is in the spring, so that we've already had it for this year, but be on the lookout for next year. We also do a Victim Assistance Academy annually, again in the summertime, and that's a great free training for folks to go to, so you want to keep an eye out for that. And then I want to mention that the coalition is celebrating our 35th anniversary, so we're very excited about that, and we will be hosting our annual Pearls and Pinstripes event in October. It's actually set for October 5th this year. It will be an event to kick off Domestic Violence Awareness Month. And so we hope that if you can join us, we would love to see you at the event as well. So thank you so much for being on the call today. And let me take a quick look at questions. It looks like we had one question related to the Safe at Home confidentiality process. Do we have the ability to apply or utilize this program for our clients? Is there a website for the application process? Again, this program right now, the Secretary of State is working on the process. So the program won't go into effect until March 1 of next year. So right now, there isn't a process to apply, but we will be keeping you guys informed. We'll be emailing stuff out. We'll put it on our website. We will also, once the program is in place, we'll probably do a webinar on it. We will include information about this program in our regular trainings that we do, like our legal advocacy training and others. So we will be working with the Secretary of State's office to get people trained around the state once that program is up and running. So I believe that's the only question that we had. Again, thank you so much, and we hope to hear from you again soon. Have a great day.